First week at a new job. HR sits you down with a stack of papers and says, just standard onboarding stuff. Sign wherever there is a tab. You do not want to seem difficult, so you sign. You hand it back with a smile. 2 years later, you are let go. You find a lawyer, and the lawyer says, I am sorry. You signed an arbitration agreement on day 1. You gave up your right to sue them before you even started. One signature. And it cost you everything. This happens every single day. Smart, hardworking people handing over their rights with a pen because nobody told them what they were actually signing. My name is Clara. This channel exists to show you the rules nobody writes down. Today we are covering 7 work documents you should never sign on the spot, what each one means, why each one puts you at risk, and exactly what to say to protect yourself. Subscribe right now, because what you are about to learn could save your career. Number 1. The arbitration agreement. You will see this during onboarding or when HR sends a policy update. They will call it standard paperwork. Here is what it actually does. The moment you sign, you give up your right to take your employer to court. Any future dispute, wrongful termination, discrimination, unpaid wages, gets handled by a private arbitrator instead of a real judge and jury. Instead of a public courtroom where rules protect you, you are in a private room with a decision maker the company knows far better than you do. The process is confidential. Your right to appeal is almost non-existent. And whatever the company did wrong never sees the light of day. What to say? I will review this and get back to you by Friday. Ask if there is an opt-out window. Many agreements have one. If they pressure you to sign immediately, sign it but right next to your signature. Received under review, I do not agree to arbitration. That creates a record, and that record matters. Number 2, non-compete and non-solicitation agreements. A non-compete says you cannot work for a competitor after you leave. A non-solicitation says you cannot reach out to former clients or colleagues at your next company. Sounds reasonable. Here is where it gets dangerous. Vague language, phrases like any business similar to ours or any client the company has ever had, can turn a narrow restriction into a career-ending trap. You could be signing away your ability to work in your own industry. What to say? I need time to review the scope, geography, and duration of these restrictions. Then negotiate. Ask them to narrow the territory, shorten the timeline, and define exactly which clients are off-limits. And if they want to restrict your future income, ask them to pay for it through severance or garden leave, where they cover your salary during the non-compete period. Number 3, severance agreements. When a company lets you go, they hand you a severance agreement, a check in exchange for your signature. Sounds like a win. Here is the trap. That signature means you are releasing all legal claims against them. Wrongful termination, discrimination, unpaid wages. You are giving all of it up, often for far less than you would actually be entitled to if you pursued it. And buried inside these agreements are confidentiality clauses that prevent you from talking about what happened, and non-disparagement clauses that stop you from saying anything negative about the company, even if it is completely true. What to say? I appreciate the offer. I will review this and respond by a specific date. If you are over 40, the law requires your employer to give you at least 21 days to consider the agreement and 7 days to revoke your signature after signing. Use every single one of those days. Negotiate for more money. Ask for a neutral reference. You have more leverage than they want you to believe. Number 4, resignation in lieu of termination. This one is the sneakiest. A manager pulls you into a room and says, "Look, I am trying to help you here. If you resign, it will look better on your record. Let us part ways on good terms." Do not do it. The moment you sign a resignation document, you almost certainly lose your eligibility for unemployment benefits. And you hand the company a clean defense against any wrongful termination claim, because according to the paperwork, you quit. They are asking you to do their dirty work for them. They want the outcome of a firing without any legal exposure. What to say? If the company is ending my employment, I need that in writing. I will not be resigning today. Then stop talking. Immediately after, send an email to HR to confirm, "My manager asked me to resign today and I declined. If my employment is being terminated, please provide that in writing." Now you have a time-stamped record of exactly what happened. Number 5. The PIP acknowledgement. When they hand you a performance improvement plan to sign, they make it look like you are simply acknowledging you received it. Read the fine print. Often, that signature means you are agreeing with the facts stated inside. You are signing a document that admits to poor performance and policy violations. A document that will later be used to deny your unemployment benefits or defeat a lawsuit. What to write instead? Next to your signature, write, "Acknowledging receipt only. I disagree with the statements herein and will provide a formal rebuttal." Then submit a short, factual rebuttal. Stick to dates, metrics, and evidence. Point out where training, tools, or support that was promised never arrived. Keep it professional. Keep it factual. Number 6. Disciplinary write-ups. Same trap, different document. You are in an uncomfortable meeting, everyone wants it over, and the write-up form is sitting there with pre-written language like "I accept responsibility" or "I admit I violated company policy." If you sign that as written, you have handed them a legally binding admission. What to do instead? Write receipt only, "I disagree," and we'll be providing a rebuttal. Keep your rebuttal to one page. Use timestamps. Reference emails. Name witnesses. No emotion, just facts. If they refuse to let you add notes, say, "Then I will email my rebuttal from my personnel file." Send it immediately to HR with the subject line, "Rebuttal to disciplinary action," and the date. Your side of the story is now on record. Number 7. Broad medical release or investigation authorization. This one flies under the radar because it sounds routine. You request a medical accommodation or you are involved in a workplace investigation and HR hands you a form to sign. Here's the trap. These forms are often written to be as broad as possible. A medical release might give the company access to your entire medical history. For an accommodation request, they only need to know your work-related limitations. Nothing more. An investigation authorization might give them permission to search your personal devices or social media accounts. What to say? I can provide a more targeted authorization. For medical issues, have your doctor write a letter describing only your functional limitations at work. For an investigation, offer to provide specific relevant documents yourself. You control the scope. Do not sign a blank check. Here is the rule that ties all 7 together. Slow down and control the record. Never sign anything on the spot. Always say, "I will review this," and get back to you. Write receipt only when a signature is forced. Submit your rebuttal in writing. Never sign away your legal rights under pressure. The company has HR. They have lawyers. They have processes built entirely to protect themselves. The least you can do is protect yourself too. Your signature is powerful. Treat it that way. Drop a comment right now. Has anyone ever pressured you to sign something on the spot? Tell me what happened. Someone reading your comment has lived the exact same thing. Subscribe if you want to keep seeing this system for what it actually is. I am Clara, and I will see you in the next one.